My name is Lucy Claridge, and I'm the Executive Director of the International Lawyers Project. For those of you that don't already know ILP, we're a UK-based NGO working to advance economic and environmental justice and the rule of law through the provision of pro bono legal expertise to civil society, communities, and governments around the world. And we partner with legal experts, such as those here at Landmark Chambers and here on our panel, to provide expert legal analysis, research, capacity building, policy and legal reform advice across 4 focus areas. The first one of those is environment and sustainable development. We also work on issues of governance and accountability, sustainable finance, and enabling the civic space. So as you'll probably have realised, tonight's event is going to be focusing on the first of those mentioned areas, environment and sustainable development. We recently had a strategy refresh, during which we recognise that the just transition is essential in ensuring that the shift towards a green economy is inclusive and equitable, particularly for those most impacted by climate change and related to the move away from fossil fuels. However, as our speakers will highlight, achieving this change has some challenges. Legal tools can help address some of those issues, and pro bono assistance can overcome the barriers that many face when seeking to access legal support. So it feels very appropriate that, in fact, tonight's event is taking place during Pro Bono Week. And we're delighted to be partnering with Landmark this evening and speaking alongside Robert from Simmons & Simmons, and we have Jackson online from the Narasha community in Kenya, in a way that is very much representative of the model that we follow with all our pro bono partners. We have some really fantastic experience on our panel today, so I'll now hand over to Satya Jeremy, our moderator, to introduce them. Satya was admitted to practice in Trinidad and Tobago in 1988, and she has a broad international practice in commercial, regulatory, public law, and defamation matters. Working with ILP, along with an international network of lawyers, she holds economic actors to account for their actions, including deflecting and neutralising the effects of SLAPP action for international clients based in England and Pakistan, among other locations. And she's also a very valued member of ILP board. Satya, over to you. Thank you.
Thank you, Lucy. My name is Satya Jeremy, and I will moderate the session today. Just to begin with, a few housekeeping notes. Your microphones, if you're attending online, are automatically muted, so you'll not need to adjust your local settings. And we very much welcome questions throughout the session. We'd ask that you please submit them via text in the Q&A section, which may be found at the top or the bottom of your screen. If you would like to remain anonymous when asking a question, please make sure you tick the Send Anonymously box before submitting your question. This webinar is being recorded, and you will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point during the webinar, we invite you to rejoin the meeting again by clicking on the original link. So let's begin with the introductions to the panel. Alex Shattock, on the far end of the table, is ranked in the Legal 500 in Chambers and Partners for Environmental Law. Alex has been instructed on cases concerning climate change, pollution, environmental protests, pesticide regulation, protected habitats, invasive species, and animal rights. His clients include NGOs and campaigners, such as the Environmental Law Foundation, Fossil Free London, Friends of the Earth, and WWF UK. Alex's topic will be domestic tools and challenges for climate action. Sitting next to Alex is Natasha Jackson, who will speak after Alex. Natasha is ranked as a leading barrister in public, administrative, and human rights law. She also practices in environmental and planning law. Natasha is on the Attorney General's panel for Junior Counsel. Natasha's topic will be climate litigation in the European Court of Human Rights. Maria Cristina Mundin.
Jane Potter.
Sorry. Maria Cristina Mundin, who's sitting at this end of the table, is a Philippines qualified lawyer, and she leads the International Lawyers Project's Environment and Sustainable Development Program. She started her legal career working in the Office of the Solicitor General, where she defended the constitutionality of laws and state policies, particularly in energy, natural resources, and government infrastructure projects. She also worked as a law clerk in the Supreme Court of the Philippines. As a law lecturer, she taught environmental and natural resources law and administrative law. Maria Cristina is discussing ILP's work on using legal remedies and tools in addressing just transition challenges in global South countries, particularly those involving renewable energy development projects and transition minerals mining. Robert Allen, sitting next to Maria Cristina, is a partner in Simmons & Simmons. Simmons & Simmons is an international law firm which has been around for more than 100 years. Robert's main focus is retail and consumer finance litigation. He has advised on a range of disputes and industry-wide issues, including consumer credit, mis-selling, litigation, and unfair terms. Robert will be discussing changing trends in the use of litigation, regulatory enforcement, and other dispute fora. For example, OECD complaints, advertising regulators, etc., to achieve climate justice globally, but with a brief focus on UK regulators and quasi-regulators enforcement. Robert's topic is dispute resolution as a tool for climate justice. And last but not least, Jackson Shah, who is joining us online, I believe from Texas. Jackson is the executive director of Narasha Community Development Group, advocating for indigenous rights in Olkaria, Kenya. He has challenged international financial institutions and corporations, including the World Bank and KenGen, to ensure sustainable development respects indigenous rights. Jackson is pursuing a PhD at Texas Tech University, USA, and he will discuss empowering communities for climate resilience and just energy transition. Over to Alex.
Hi, everyone. So my talk focuses on domestic tools and challenges for climate action. And I particularly focus on how lawyers can support climate protesters and help bring strategic environmental litigation more generally. I understand we have a broad audience. Some of you will be very familiar with what I'm about to discuss. For others, it will be mostly or entirely new. So I've hopefully set it at a level of detail where absolutely no one is happy. That was my goal. UK environmental law, what does it mean? I purport to be an environmental lawyer, but what law am I actually playing around with? Well, UK environmental law, as we see on the slide, is a bit of a patchwork. Lots of law we picked up from the EU, and it's quite dense. Take the Water Framework Directive, for example, the basis of water quality assessments in the EU, and for the time being, we still follow it here in the UK. Here's what Advocate General Cockott said about it in a CJEU case called Bund, bearing in mind AG Cockott's probably the most knowledgeable environmental lawyer in the European Court of Justice. Here's what she said. Even though the directive sought to establish a fundamental common basis to coordinate the patchwork of community and national legislation in force, the fact remains that the directive is a complex and particularly elaborate measure, which is unusually difficult to understand. In particular, many difficulties are raised by the legislative drafting technique of making numerous references from one provision to another and to other measures, and of laying down several derogations, the scope of which cannot be clearly identified. So that's the CJEU's top environmental lawyer. So no hope whatsoever for the rest of us. Generally speaking, EU-derived law is quite exacting if you can manage to understand it, which is a big if. But it is, in the UK at least, poorly enforced by the Environment Agency and other relevant bodies. In the UK, we also have another quite elaborate statutory system relating to town and country planning, which the government's always tinkering with. This usually comes into play when you want to challenge a new fossil fuel project or other environmentally damaging scheme. If you're an environmental protester, you can rely on freedom of expression, assembly, other human rights. You can also rely on them in climate challenges more generally nowadays, more on that later from Natasha. We have a system of carbon budgeting and accounting, which again can give rise to fruitful legal challenges. We have a quality law, which when we think about just transition is particularly important. Are we protecting groups particularly adversely affected by action or inaction if they have protected characteristics? For environmental judicial reviews, we have the benefit of a cost capping regime in the UK, which largely, though not entirely, extinguishes the chilling effect of adverse costs liability. But overall, it's not the worst legal ecosystem, and there have been a number of climate change related challenges successful in recent times, not least because of the perhaps questionable decisions of the previous UK government. I don't think the new one will put us out of a job, though. It's not all rosy, though. Climate change is obviously very worrying to all of us, and in the past 5 years or so, a number of groups have had the temerity to actually try and do something about it through non-violent protests. That didn't go down well, and the previous government introduced a raft of new criminal offences and police powers. So nowadays, you can be arrested for intentionally or recklessly causing an act in public that risks causing serious annoyance. And of course, if a protest isn't annoying, it's not really a protest, is it? And gently leafleting outside Asda is probably not going to provoke the kind of trajectory change needed to avoid the Earth becoming a post-apocalyptic hellscape in a few short years. The threshold for intervening in a protest now is a lot lower. The police can intervene if you are causing a hindrance that is more than minor. That is basically my entire legal practice, causing a hindrance that's more than minor. Other offences too. The ancient English liberty of gluing yourself to a building is now unlawful, for example. Plenty more examples. What to do? Well, along with ILP, I've been helping to advise protesters on what they can and cannot do in this bright new legal landscape, emphasis on the cannots. Part of the chilling effect on protest comes from the vagueness of these new laws. So helping to shed a little light on them, helping to show where the line is between lawful and unlawful, hopefully a little helpful. Part of our work has also been just helping people to know that they can get legal advice. If you have restrictions placed on you personally as a protester, as you can get now, to what extent might it be said your legal advisors are collaborating with you, for example? There's a lot of worry about conspiracy charges and whatnot. Can you as an organisation be liable for someone who glues themselves to a building wearing your T-shirt? Those kind of questions. But there is overall a trend in the UK restricting the right to peaceful protest. Another trend admittedly a bit slower, but also inexorable, is restricting the right to bring strategic litigation. So for judicial reviews, which is the UK form of administrative review, there's now a permission threshold you need to get across. There's a 6-week time limit to bring a challenge to new development in the planning context. It's not long at all. You may get a cost cap, but someone can now argue it should be a lot higher. There's very high deference to government scientists, and recently an even higher bar, it seems to me, to bring your own scientific evidence that you're an expert in. So when you are a claimant in these kinds of cases, pretty much all the cards are held by the defendants, and you have an uphill battle. All the more surprising then that there have been quite a few notable successes in UK climate and other environmental litigation this year, unusually so, particularly Finch in the Supreme Court, but also the Net Zero Strategy Challenge Round 2 and the Cumbria Coal Mine Challenge. All successful. But there are limits to even these legal successes. Climate litigation is not a silver bullet, more of a hammer, perhaps Maxwell's silver hammer, if that's one people cut for the evening. It's blunt, it's imprecise. Ultimately, the person whose job it is to make political decisions is the political decision maker. So you can slow them down. Sometimes you can even stop them entirely, but you can't easily get the courts to tell them how to do their jobs. So climate litigation probably isn't very effective on its own. It needs to be deployed alongside political advocacy. You can't do it that way because it's unlawful, Secretary of State. We think you should consider doing it this way. Here are the reasons why. The two-pronged approach. Another limitation, particularly in the UK, it's quite hard to judicially review in a vacuum. You need something, a decision or action for the judicial review to attach itself to. That's not to say you can't make sweeping systemic points, but in the UK, you usually have to make such points in the context of something more narrow, the publication of a document or a decision to do something or not to do something. And the final challenge to effective climate action, I've been mulling this point over quite a lot today in light of the US election results, political labelling. Don't think that as a claimant lawyer, you won't be dragged into your client's political battles by their opponents, because you will. Every legal success our clients have will usually provoke a reaction, and framing a successful legal challenge as another woke attack by lefty environmentalist lawyers is a pretty good way of delegitimizing our client's success. And this kind of political framing of legal challenges fits a wider narrative that's being pushed about the sorts of people who bring strategic climate litigation. We're often painted as self-satisfied North London elites driving to our vegan dinner parties in electric cars that no one else can afford, where we plot to take good industrial jobs away from those in the areas that need them the most. The populist right are very good at framing their opponents in a way that isolates them from their natural consistency, and perhaps we see some of that in America today. Those tactics, which are very effective, we're beginning to see in the UK too, being deployed against environmentalists and environmental lawyers. In her short-lived Conservative leadership campaign, former Home Secretary Suella Braverman described support for net zero policies as a, quote, luxury belief, a very clever turn of phrase in my view. She said, our politically correct critics have money, they have status, and they have loud voices. They have the luxury of promoting seductive but irresponsible ideas, safe in the knowledge that their privilege will insulate them from any collateral damage. She's talking about net zero policies. Now, the sheer audacity of Suella Braverman claiming to represent the disenfranchised, but we know from the US, we know from today, it's effective. The new leader of the opposition, Kemi Badenoch, talked in a pamphlet just a couple of months ago about a new bureaucratic class that has emerged in the UK, including, shock horror, new legal specialisms such as environmental law, which is now, she says, a career in itself. Can you imagine? So as environmental legal professionals, we can't help. We can't avoid being dragged into a political labelling exercise aimed at delegitimizing what we do. What we can do, though, is help fight against this notion that we and our clients are green elites and that climate change isn't a problem that affects everyone and that it isn't a working class problem. Of course it is. It affects the poorest the most, as we've seen all around the world in recent years. Most of my clients are acutely aware of the labels their opponents try to use and actively bring in local residents, local groups, affected people into strategic litigation, the voices of the ordinary people on the front line. And that's absolutely the way to do it. And if we're going to have any hope of carrying the majority of people with us as part of the transition to a fossil-free world, then it seems to me that approach is absolutely essential. Don't talk at people about climate change, don't talk down to them, but bring their voices in. I'll now hand over to Natasha.
Thank you, Alex. So Alex has been talking about some domestic remedies and how we can use the courts here in England and Wales to achieve climate justice. I'm going to be looking slightly further afield at how human rights law is increasingly being used as a tool for climate justice at a more international level at the European Court of Human Rights in Strasbourg. Just before I do, anyone listening online, if you do have any questions to ask the panel, we will have time for those at the end, but if we could just ask if you could pop those into the question box and then we can come to them when we finish with the speeches. Thank you. So the Strasbourg Court, as Alex said, there are some of you who may be incredibly familiar with the European Court of Human Rights, but I know that that knowledge level isn't to be expected. So I'm just going to start with a bit of an overview on what the Strasbourg Court is. So the European Court of Human Rights is an international court of the Council of Europe, which is responsible primarily for interpreting the European Convention on Human Rights. And just to be clear, even though Brexit has happened, the UK is still a member of the European Convention of Human Rights, and it is part of our domestic law under the Human Rights Act 1998. There are 46 states who are parties to the convention, and therefore the convention applies in those member states. But there is also some case law establishing that obligations owed by contracting parties can apply extraterritorially in certain circumstances, such that remedies can sometimes be secured against a member state operating overseas. And I might say a little bit more about that a bit later in the talk. The Strasbourg Court hears applications alleging that a contracting state has breached the rights that are protected under the convention. Applications can be made by individuals or groups directly to the Strasbourg Court, although, and again, this is a theme that we'll pick up on, there are certain standing requirements, as well as requirements that domestic remedies, so litigation in domestic courts, needs to be exhausted before you can bring a claim to the Strasbourg Court. The rights that are protected under the convention are fairly wide-ranging, but specifically for our purposes include, and you can see that they're set out on the slide, Article 2, which is the right to life, broadly uncontroversial, but actually sometimes more so than you might expect. Article 6, which is the right to a fair trial. Article 8, which is the right to private and family life. And also Article 14, which is the right to protection against discrimination. So climate rights litigation using the rights protected under the European Convention of Human Rights is a relatively new addition to the Just Transitions litigation toolkit. And there have been a number of really quite exciting judgments this year, which has started to pave a path for human rights litigation as a tool to achieving climate justice through securing remedies against state actors. And there are three cases in particular that I'm going to talk about, and they're set out on the slide, but I'll come to those in a minute, because just before I talk about those cases, I did want to spend a second talking about a Dutch case, the Uganda case, which was a really important prior decision in the Dutch courts, which is often heralded as a pioneering case on the European Convention on Human Rights being used to secure climate justice. The Uganda case was brought by a Dutch environmental group, the Uganda Foundation, as well as 900 Dutch citizens, who claimed that the government was required to do more than it was doing to prevent global climate change. And they claimed, among other grounds, partly rooted in European Union law as well, but sticking to the human rights for our purposes, they claim that the failure to do so was a breach of the right to life under Article 2 and the right to private and family life under Article 8. And the domestic courts in the Netherlands found that the Dutch government's existing pledge to reduce emissions by 17% was insufficient to meet the state's contribution towards UN global temperature goals, and that the government was therefore in breach of both Articles 2 and Article 8. And the courts accordingly ordered the Dutch government to limit greenhouse gas emissions to a level at 25% beneath the 1990 level, and to achieve that by 2020. So this was a really important and, as I said, pioneering decision in using a human rights framework to achieve really quite tangible outcomes in a domestic court. And while this Uganda case, being a Dutch case, is not binding in other jurisdictions, it laid really important groundwork for the decisions that have now followed in the European Court. And it remains a really quite landmark authority or case in this area of law. So onto the cases in Strasbourg. So the first case that I want to talk about is the Swiss women case, the Kleine Seniorinnen case, which I'm sure I'm pronouncing badly, which had a fair amount of publicity and was decided in April of this year. The case was brought by an NGO representing more than 2,500 older Swiss women who all argued that their government's failure to adequately mitigate global warming violated their human right to life, again, Article 2, and health as part of their private life under Article 8. And the Strasbourg court ruled for the first time in that jurisdiction that the Swiss state's failure to take actions to mitigate climate change breached the women's Article 8 rights to a private and family life. And this decision was reached, interestingly, on the basis that Switzerland had failed to adopt a domestic regulatory framework to quantify national greenhouse gas emissions and meet its own reduction targets, which was set out in the Paris Agreement and the 2030 and 2050 climate goals. So we're looking at the court focusing on the extent to which a state is putting into place a regulatory framework that adheres to its international targets. And the failure to mitigate, they claimed, the women claimed, gave rise to climate change-induced heat waves, which posed a particular risk to them as older women. And the NGO bringing the case advanced extensive and really complicated scientific evidence in order to support that case, which was a huge factor in why it was able to succeed. The court also found that the state had actually breached the women's Article 6 right to a fair trial because it had failed to hear the women's legal challenges against the authorities in action domestically, which also is an interesting point to pick up on and ties in with what Alex was talking about potential tools that we might be looking to use in our domestic courts as well. So as I said, this is really truly landmark ruling that has been heralded by many as the start of a new wave of climate-related regulation and litigation to ensure that responsibilities are met. And it establishes a valuable precedent on the causation between environmental threats and the human rights of those impacted by them. And we expect and hope that this will likely impact litigation in the domestic courts of contracting states seeking to hold their governments to account. So I don't have tons of time to talk to you, but if you'd like to find out more about this case in particular, Landmark Chambers did host a series of seminars and published blogs on this case and the others that I'm about to canter through and the implications of those decisions earlier this year. So if you're interested in reading more about this, then hopefully we can send out the information about that when we send out these slides, and I'd encourage you to take a look. I think I've gone too far. So just to briefly then touch on the Carême and the Duarte Agostino cases. These were two cases that were also determined at the same time as the Swiss women case, but they serve really more as a cautionary tale about the procedural rules in the Strasbourg court, as well as hopefully giving some optimism on possible arguments that we might want to run. So in Carême, the case was brought by a former mayor in northern France, and he requested that French authorities implement a number of climate change measures back in 2018 and applied for a domestic judicial review when nothing happened about that. He ultimately lodged an application in the Strasbourg court, alleging that the French authorities had failed to take appropriate action in violation, again, of Article 2, right to life, and Article 8, right to private and family life. Unfortunately, though, by the time that the case was heard by Strasbourg, the applicant had moved to Brussels, and so his personal claim was rendered inadmissible by the court, as they considered that he was no longer properly a victim of the French state because he was no longer residing in the French state. And his kind of separate hat as mayor, that aspect of the claim was also found to be inadmissible because government organisations don't have standing under the convention. So a disappointing outcome, but not an outcome actually on the substance of the points that he was raising in the Strasbourg court. But as I said, a bit of a cautionary tale about dotting the I's and crossing the T's if that's the way around, yeah, if you're thinking of litigating at that level. And the Duarte Agostino case, similarly a bit of a cautionary tale. This was an interesting claim brought by 6 Portuguese young people against both Portugal and 32 other contracting states. And I said at the start that I might touch on extraterritoriality in this talk. I don't have tons of time to talk about it, but this is where we're looking at that. Their claim, again, was pursued under Articles 2 and Article 8, and they also brought an Article 14 discrimination claim. And it was focused on the impacts on their well-being, and in particular in relation to wildfires, which are obviously a huge issue at the moment in Portugal and huge swathes of southern Europe. And this case as well was also deemed inadmissible by the Strasbourg court. Firstly, because all the countries were not Portugal, and the Strasbourg court took, in my view, slightly disappointing view that because the applicants were in Portugal and it was looking at territoriality, it needed to only be looking at Portugal as a respondent to the application, which is, something that I think is going to merit a lot more thought as we go forwards and are dealing with something that is inherently extraterritorial by nature and can't be portioned easily into which state is responsible for truly international obligations. But that's why it was deemed inadmissible against the other states, and then it was deemed inadmissible in Portugal, against Portugal, because unfortunately those 6 applicants hadn't exhausted domestic remedies, so they hadn't tried to pursue their case through the Portuguese court before applying to Strasbourg. So again, as I said, another cautionary tale there, but once again, not a decision actually on the substance of the application that was brought. So that leaves us with what next, and raises the question of where we go from here. So firstly, my first comment would be that all contracting states from the European Convention on Human Rights do incorporate convention law in some way, and that means that litigants in the domestic courts will be able to use the findings in the Swiss swimming case in a similar way to how back in the Uganda case, Dutch litigants were pursuing remedies in the domestic courts there. And it will be really interesting to see what happens domestically here in the UK and in other contracting parties in pursuing applications against the states. It will also be interesting to see the extent to which further litigation expands the circumstances under which rights breached will be found to be failing to meet international commitments. So that kind of focus on the regulatory requirements and whether they're up to scratch. We've looked at that in certain regulatory regimes so far, but it may well be that there are other international standards that are not being met that can be the states can be held to account in respect of through litigation. And also perhaps slightly optimistically, we can also hope that these successes in the courts and the continued successes of this litigation on human rights grounds might also incentivise state actors to take steps of their own accord to meet international commitments and to work towards achieving a just transition. And finally, there's every reason to expect and hope that the decisions of the Strasbourg court will also percolate outwards on an international level, and perhaps even international courts will go further and actually on that territoriality issue I was talking about, you can see that actually other courts internationally are being even more progressive than the Strasbourg court. So there's scope for hope that this will have a more international impact still. So that's everything from me. And can I hand over to Maria? Thank you.
Thanks, Natasha. Good evening, everyone. Thank you for joining us today. And Alex and Natasha already discussed domestic international legal remedies to fight for climate justice. Now, but most of our partners are civil society organizations and communities. So one of the most common question that we get asked in International Lawyers Project is, where do we begin? And we begin by enhancing the capacity of communities and civil society to tackle just transition challenges. So how do we do this? First, we provide capacity building for indigenous communities and civil society organizations on the impact of green development projects and investments in global south countries. So this covers renewable energy projects, carbon markets, and mining of transition minerals. The idea behind it is that we empower communities and civil society organizations to understand what their rights are. We build their legal capacity, their legal knowledge and skills, because remember, knowledge is power. And for these communities, it is important that they're able to navigate the complex legal frameworks within their jurisdiction and even international laws that affect their country or the development projects that happen in their country. Now, I'm going to cite 4 examples that we worked with. The first two is we work with the Ogiek community, Ogiek People's Development Program, and the Maasai community from the Narasha Community Development Group in Kenya. So we provided training for them earlier this year on topics such as indigenous and customary land rights, on free and prior informed consent, on what environmental impact assessment, a proper one, should look like. And the idea behind it is that they themselves are able to negotiate for their land rights, defend themselves, and actually amplify their voice so that they have a voice and a seat at the table. We also actually train them on negotiation techniques because it goes further beyond just litigation cases and dispute resolutions. They also need to be able to negotiate for themselves and to further their advocacy and raise their own awareness within their community members. Now, the third project is with East African Wildlife Society. So recently, 2 months ago, we held a virtual capacity building for them on carbon markets. Because earlier this year in Kenya, carbon markets trading regulations was introduced. And civil society wanted to understand the basics about carbon markets, but because it is complex. So we work with volunteer lawyers to help them unravel those technical legal frameworks that might hold them back from having a successful carbon market. And one of the things we highlighted is that the need for free and prior informed consent, because the communities need to know that they should be able to navigate the carbon markets and need to know what their rights are and what they should hold their own government and companies accountable under the law. And last but not the least is we work with Bantay Kita PH or Philippines. That is the Publish What You Pay Philippines chapter office. We held a virtual training for them on just transition and just mining of transition minerals. The idea behind it is that they wanted transparency and accountability in the mining sector. For a lot of the indigenous communities that they work with, the problem was that they didn't have a rightful place in these discussions. For example, royalty management. They didn't know what free, prior, informed consent was, and that it should be quality FPIC process. They didn't know what EIA was. They didn't know what the benefits should be to them. And so there were 2 parts to the series. First is we actually looked at domestic laws. What are the mechanisms that they could avail of? Whether it's petition for a writ of kalikasan for environmental harms in their land, or it could also be understanding the Indigenous Peoples and Rights Act in the Philippines. The second part of the training was actually looking at international mechanisms, some that have been mentioned by Natasha already, and some that will be discussed by Robert, our next speaker. And So what else aside from capacity building? Another thing that we support on is actually legal research on international best practices and standards and development of toolkits. So you might think, how does this help? It actually helps raise awareness and helps the organizations that we work with or in the indigenous communities we work with further their advocacy and cause. Because again, they need to build that legal literacy to understand that there are gaps in the law, what should be the international best practice and standards. And two examples that I wanted to highlight is the work we did with Green Hydrogen Organization. We actually designed with a team of lawyers model contracting principles that should be present in any green hydrogen project. And what we wanted to highlight, and this is publicly available if you go to their website, we highlighted the community transparency and engagement should happen throughout the project. Because it is so important, because no infrastructure or development project will ultimately be sustainable without the buy-in or the participation of indigenous communities where the development projects are located. Second is research on human rights violation linked to environmental harms in mining companies in DRC. Now, as a transition mineral mining economy is booming, the road to a green economy is paved with a lot of challenges and a lot of problems and a lot of violation of human rights and environmental harms. So the research actually helped the organization understand what companies whose office are in global north countries should actually be implementing in the countries. And some of the findings that they found is that some companies are just doing the bare minimum to comply with domestic laws, but they are not actually complying with the law where their main offices are located. And last but not the least, after the capacity building, after building that legal literacy, we can actually give legal advice and strategic litigation advice on domestic and international mechanism if it comes to that. So first we look at domestic court action. Sometimes you first look at what's available, what laws are or the legal frameworks in certain jurisdictions. It could be simply filing an injunction or looking at procedures or special laws in that country to achieve climate justice. And if domestic laws are not feasible, we look at filing before regional tribunal courts such as East African Court of Justice, African Court on Human and People's Rights, and Economic Community of West African States, among others. So we also support with the implementation of court rulings because sometimes our partners do get favorable rulings before these regional and tribunal courts. But the problem is the government is unable or refuses to implement them. So we also look at that. How do we help them push for the implementation of these court rulings? And last but not the least, we also support on amicus curiae and other submissions before regional and international tribunals. And as I end my discussion, I'd just like to borrow the words of one of the community members we work with in Russia. His name is Joseph. And after our training, he said what he realized was that the law is both a shield and a sword. And so it is just a reminder for everyone, us in the legal community, that we could actually use the law as a tool to either defend or protect the rights of the marginalized or to hold actors accountable for environmental harms and violation of human rights. Thank you. And I'll hand this over to you.
Thank you, Maria. In the time I've got, I'm going to illustrate in, I suppose not a huge amount of detail, but some of the other litigation and related litigation tools that have been used to achieve just transition. I call some of them resolution ancillary or adjacent tools because as we'll see, some of them are broader, not entirely court-based solutions. In talking about it, I think there are two things that I want to not necessarily advocate, but raise as questions. One is the approach to climate litigation, which is essentially appealing to the wallets of investors and looking at certain claims that look at the financial risk that companies are taking by continuing to fail to transition, the risk to their investors, to their shareholders. But also I want to look at and illustrate the value, the capital of reputation as well, which is quite important in this area. So in many cases, it's the availability and knowledge of these tools that's often as important as individual examples of success. And some of the examples I will go through, you will see have had varying degrees of success. Sometimes these claims are successful for the claimants, other times they're unsuccessful. That in itself is an argument for a variety of different approaches, but it's also true that despite mixed success, the fact of an action and attendant publicity is often effective in at least affecting some kind of material change. So successful strategic climate litigators such as Client Earth will announce as soon as they can that they're taking action on something and make sure everyone knows that. That is an important key step, raising awareness of their actions, the issues with the defendant organisation or government, and hopefully, coming back to this point, raising concerns with significant investors and stakeholders. So the types of action are pretty varied, as displayed on this slide, and they reflect these different angles of approach. But I'll start by touching briefly on regulatory enforcement. So it's specifically effective as a tool in itself and what we're talking about. We haven't got as yet, perhaps ever, activist regulators, but because it can form the foundation or the trigger for further action shortly. So these first few slides give some examples of regulatory activity. And I'll start with the Australian Securities and Investment Commission, its fine of Tulu Energy in October 2022. So ASIC alleged that Tulu made 4 false or misleading statements about its Botswana natural gas-fired power plant, and they included claims that Tulu had environmental approval and that it was equally concerned with producing clean energy from renewable sources. Now, the fine, as you'll see from the slide, is tiny, but it was the first ASIC fine, and it ensured a very high-profile decision and reputational damage for the company. But at the other end of the scale, we've got much more significant SEC fines. And these fines, while painful on their face, obviously, can still have the effect of driving down value for shareholders, and so are of significant importance perhaps to those people who wouldn't necessarily care so much about some of the underlying issues here. So I'll just touch on the bail decision. That's another first. It was the first case brought by the SEC's Climate and ESG Task Force, and it charged the company with making false and misleading claims about the safety of its dams prior to the January 29 collapse of its Brumadinho dam. The SEC had stated that since 2016, the company had manipulated dam safety results and been dishonest in its disclosures. In applying the, getting to the settlement where the company agreed to pay $55.9 million, the SEC said many investors rely on ESG disclosures like those contained in Vail's annual sustainability reports to make informed investment decisions. By allegedly misrepresenting, I had to say allegedly because they were reaching assessment, by allegedly manipulating these disclosures, Vail compounded the social and environmental harm caused by the dam's tragic collapse and undermined investors' ability to evaluate the risks posed by Vail's securities. So that is the, on paper, that is the reason the SEC is interested. It's the returns to investors, but you can see that the effect of how it can help contribute to a just transition. The Goldman Sachs one there, which I won't go on to. So that's regulation in the world. In the UK, we haven't seen much from regulatory bodies, to be fair. We're a bit behind there. However, the UK's Financial Conduct Authority recently introduced an explicit anti-greenwashing rule for regulated bodies such as banks, insurers, asset managers to comply with. This will, I think, undoubtedly trigger complaints and litigation from affected consumers. And so, again, it's regulatory activity as a springboard for climate litigation or litigation adjacent, i.e. complaint type activity in order to achieve a just transition. So in terms of the litigation itself, I've heard a bit about greenwashing, and certainly the most high profile and common subject of climate justice litigation. But as well as the subject, in all these bits of litigation, what's interesting, well, one of the things that is interesting is the mechanisms and procedures by which they are brought. Collective action procedures, for example, developing very much here in the UK in different areas, whether it's in the Competition Appeal Tribunal or in the High Court, vehicles by which huge classes of affected individuals can get together to achieve some kind of justice with the help of well-remunerated litigation funders, of course, and other springboards, novel springboards for action. I won't go through these cases in too much detail, just so I can get through or get to what I want to talk about in terms of reputation. But please feel free to look at the details on the slide at your leisure. As well as greenwashing, another key angle for litigation is bringing actions against governments and organisations, not accusing them of misrepresenting their green credentials, but of course accusing them of being directly responsible for climate change. And these two Client Earth claims are good examples of this. I think Alex briefly alluded to the second one, the net zero strategy released by the old government in October 2021. The allegation was that it breached the UK's duties under the Climate Change Act, as it wouldn't reduce emissions enough to meet the carbon budgets under the Act. That in turn risked the UK having to take more drastic climate change mitigation in the future, which would disproportionately affect young people's rights to life and to family and private life under the ECHR. Claimants also alleged that the net zero strategy overly relied on unproven technologies such as carbon capture and storage, and that by not considering how factors such as age, gender, race and disability affected people's vulnerabilities to climate change, the net zero strategy was in breach of the Equality Act 2020. That is a great example of bringing in a large number of connected arguments, and obviously the High Court then ruled that the UK government's plan to reduce greenhouse gas emissions to net zero by 2050 was too vague and therefore unlawful. That was a government, but there have also been, of course, important decisions holding corporates to account. Again, I'll just choose one example here. Allegations that Shell's contributions to climate change violated its duty of care under the Dutch Civil Code and human rights obligations. So here the claimants alleged that Shell's knowledge of climate change, misleading statements and inadequate action to reduce climate change supported a finding that Shell unlawfully endangered Dutch citizens and engaged in actions constituting hazardous negligence. And they asked the court that for a ruling that Shell had to reduce its CO2 emissions by 45% by 2030. The court came back by compared to 2010 levels. The court came back and ordered Shell to reduce its emissions by 45% by 2030. So not quite what they wanted, but getting there. They wanted net zero by 2050 as well. Now, while that judgment was founded on a duty of care to Dutch citizens under the Dutch Civil Code, it of course demonstrates that some national courts are increasingly prepared to hold multinationals to account and utilise a range of novel enforcement options regarding their obligations under the Paris Agreement and also their emissions, in particular their Scope 3 emissions. But then coming back to my original theme of using the losses or potential losses of investors to affect climate justice, there are the arguments that by not complying and by not looking at formulating proper transition policies, companies are putting themselves at risk and putting themselves in the path of financial harm. And these two top claims on this slide, McGaughey and the University Superannuation Scheme, and McVeigh, two theoretically similar, based on similar type of subject matter claims, which had two different outcomes at two different sides of the globe. I'll start with the USS one. So the USS is essentially the biggest pension provider administrator to the universities, one of the biggest pension funds in the UK. Now, members of that scheme, so university lecturers technically, and many others, issued a derivative claim against the directors of USS based on the directors' duties to act in the beneficiary's best interests under the Companies Act and their broader fiduciary duties. And they argued that fossil fuels have been the worst performing asset class since 2017, and the failure of the directors to create a credible plan for disinvestment from fossil fuels are prejudiced and would continue to prejudice the success of the company. The USS had announced that it was going to become net zero by 2050, but the claimant said that the company had no credible plan for achieving the goal. No credible assessment of the financial risk to the company posed by climate change had been provided. That claim was ultimately unsuccessful. Unlike McVeigh and Retail Employees Superannuation Trust, REST, over in Australia, which predated it, and that action also sought to highlight the legal obligation of pension fund trustees to understand and manage the risks that climate change should have in their investment decision-making process, and the significant and systemic risks posed. This had a happier outcome, I suppose. Following a hearing, there was a settlement, but that settlement involved REST making a public announcement saying that they acknowledged climate change was a material, direct and current financial risk to the fund. The investment managers would take active steps to manage the risks, and that policy required disclosure of climate change risks and related management strategies in relation with regulatory frameworks. So an example of how affected beneficiaries, or read investors, can make a difference to a company's policies there. And that's what shareholder resolutions effectively are, really drilled down. And about 2 to 3 years ago, there was a rash of activist shareholder resolutions, that the most high profile one being Engine Number One, getting director on the board of Exxon, a couple of directors on the board of Exxon. And they were climate conscious directors. You can see there also HSBC, BlackRock, Wells Fargo, Apple have all faced the same thing. While that was initially successful, I think there are questions now as to how effective that kind of strategy is. It's been reported that the Exxon effect has been negligible. And as we know, there is plenty of anti-ESG in big multinational companies on board level going on at the moment. And that brings me to raising the question about investment pressure, or pressure on investors to drive climate change. While one can see the benefit, as I've just outlined, of trying to rely on investors' pockets and returns, there is of course a kind of overhanging question, which is, and luckily there's without the scope of this talk to answer it, can there actually ever be such thing as green capitalism, which essentially that is. And so to my last points, advertising and complaints and reputation. And I wanted to finish on this because these are areas that aren't necessarily always in the front and center of climate litigation, using dispute adjacent mechanisms in order to achieve just transition. But certainly in the UK, we've seen some very effective actions by the ASA, which is effectively a toothless regulator or quasi-regulator with no powers of fining and no real powers at all. It can order people to stop advertising something, but often by then the advertisements already come down. But what the Advertising Standards Authority does is write its judgments, its final notices, whatever you want to call them, in quite easy to understand language for journalists. And you will always find journalists reporting on them. And in particular, the HSBC, which is surprisingly enough, more or less the only financial institutions finding greenwashing finding by the ASA that concerned 2 bus advertisements that featured verifiable claims but omitted significant other information that received across the board coverage and really hit HSBC's reputation hard. Its head of sustainability was pushed into making some slightly ill-advised comments and had to quit, and it's had a long tail. And so those, and that was the result of complaints being made about the advertisement. And there are other fora as well where one makes complaints, OECD complaints. Again, arguably, the effect or impact on them on certain organisations which choose not to comply with the process, choose not to involve themselves in mediation, means that from a bottom line point of view, it might be affected. But again, the reputation in having an OECD finding upheld, pretty easy to access the database, it's quite easy to understand the complaints, if not always the outcomes, means that these routes shouldn't be underestimated. I hope I haven't gone over too long, so I'll hand over to Jackson.
Thank you. I'm Jackson from the Russia community. And I'm here actually to discuss about empowering communities for climate resilience and just energy transition. This is very important to us because, you know, we come from a community where energy projects are situated, for example, geothermal projects. And therefore, the community has been actually struggling for a long time on many issues, including climate change and other issues that are emanating from these particular projects. The Orkaria, because that's what I wanted to actually to talk about, where the community is located. We live in Naivasha, a place called Orkaria in Kenya, where geothermal was discovered back in 1970s, and more exploration were done in 1980s, and more projects came up in the year 2000 up to now. And as a result of these projects, a lot of things has been happening, leading to impacting the community negatively in some cases, although in some other places, we can also see some benefits. But before I go there, I want to talk about what are these projects, the purpose and the reason for these projects. According to the government policy, these projects has great potential of producing power and ensure that the government achieve their goal of providing accessible energy to the country. But unfortunately, a list has been actually done to address the negative impacts related to these particular projects. These are the projects which are actually located in our area. We have a place called Menengai, where we have GDC and funded by several project financiers. We have Orkaria, which has said already 5 projects which are active, and they're planning to put up other. And therefore, due to these particular projects, we find the community have been actually struggling through many things, particularly in the place called Orkaria. When you look at Orkaria specifically, where we have Orkaria 1, Orkaria 2, Orkaria 3, Orkaria 4, and potential of Orkaria 6 and Orkaria 7, which are being undertaking feasibility studies, the community is struggling to sustain the economic life and also their cultural life. And therefore, these projects have been actually impacting them negatively, which I'll discuss later. Energy projects in our area actually has a lot of impact to the community. One being the relocation of indigenous peoples from their land, losing what they actually been depending for their grazing. Maasais are known for keeping livestock, and therefore it has been a challenge for them to survive. Their water access areas have been cut away from them, and also losing their cultural sites. For example, around Orkaria 1 project, we have the Oljorua Gorge, where the community has so many historical sites located within, and now they cannot access them. For example, the Fisher's Tower, they call it Fisher's Tower, but for us, we call it Kaibatani, which has a lot of history of the community. And then we have the caves, which are within the gorge, and all these, the community can no longer access them. We have also lost the historical sites that I've actually mentioned, and at the same time, our economic resources. For example, getting to the Lake Naivasha, we have been actually cut off because the government decided to take away our land for conservation, but finally they end up actually doing the project, the geothermal projects or energy projects. And the result of that, we end up being cut away from the resources like water, and therefore it has been a challenge for us. We have been struggling to access that. Beside that, there's been actually a challenge to compensate damages. For example, in 2018, we had a flooding which happened around Okaria 4 project, where we lost a number of people. But lack of policies in our country, or clear policies or community understanding on how to engage with the government and demand for compensation, we end up actually losing and no adequate compensation on the project, or on the impacts of the project. There's also less consultation that has been happening. And in most cases, for example, Arcadia Kengen has actually introduced what we call the steering committees. But unfortunately, the steering committee never address the community issues or the community concerns. They end up actually be tools for robbing the community their rights and rubber stamping what the companies are actually interested to hear or actually to be done. At the end of the day, the community are the one to lose. Therefore, in that case, we find that it has been a serious issue affecting the community. And as Narasha community with friends, we have been working out ways of trying to champion for the rights of this community by raising their voices and also educating the community on their rights. These are some of the things. We are also having legal issues related to these particular projects, not only within the Kenyan courts, but also seeking help from international judiciaries or other legal avenues. For example, we had a number of cases in Nakuru related to indigenous land rights, indigenous economic issues that have been actually impacted by these particular projects, which have been causing a challenge in terms of both climate issues and also the environmental issues. Therefore, as a result of this, we have actually thought of engaging with these companies or the government through other avenues. For example, for us, we have been using the World Bank safeguards to engage with the government of Kenya and the project implementers to ensure that the community's rights are actually protected. In 2014, we are able to raise a concern with the World Bank and the European Investment Bank, where they came and investigate and find that there is actually a non-compliance by the Kenyan government and the project implementer in terms of addressing the community issues as a result of our Arcadia 4 projects. But at that case, we still find that there's never been an adequate address to the community concerns. This is because of the capacity of the community, and therefore we have been thinking on what next can we do to ensure that the community's rights are protected. And this is where we find partnership with friends like international law projects to empower this community, one, to build their capacity to understand on how to engage, what are the tools available for them to use when engaging, and also when seeking the redress. As Maria spoke about them, this has been so instrumental in building the community capacity in seeking their rights. For example, in last year, around December, we had a meeting with Kengen when they are planning a visibility study for Carrier 7. And fortunate enough, due to the training of the community, they were able to raise serious concerns on how this project is negatively impacting the community. And especially the reports produced by these projects for their approval through NEMA and other, and seeking also financing. And this is whereby we find it was so challenging that the same projects which were involved in the Carrier 4 projects, they're still engaging or arguing that the Maasais, although they are indigenous, but they are not living and they are not entitled to that particular land. Therefore, they don't deserve any compensation. That is, these are how historical marginalization and oppression has been actually happening to Kenya, denying indigenous communities' right to be compensated of damages as a result of the projects. Therefore, the capacity building, empowering the community voices when they are in meetings and also seeking redress has been actually so supportive through this particular project we have been doing with International Law Project and others. We have also having the issue of climate change, looking at the laws in Kenya. For example, Kenya's Climate Change Act of 2016, which formed the Climate Change Commission. But unfortunately, the community still doesn't have understanding of its existence. And secondly, how they are going to use such a mechanism. And thirdly, putting the commission under the presidency's office limits the community from actually accessing services from these particular bodies. Therefore, these are some of the things we have been actually looking on how the community can be brought to understanding on what tools are available, how are they going to engage with the government, and what next if such projects or such mechanisms are not helping them. And this is where we have been supporting them to understand international policies that they can actually depend on whenever there is such kind of violations and the government has not addressed through the local mechanisms. And also promoting sustainable energy and equitable development, because energy being produced within our locality, and unfortunately, the local community cannot even access those resources. If, for example, our Carrier still has no energy when the 80% of energy produced in Kenya come from our Carrier and serving the other parts of the country. But the local community are actually being neglected, not getting any service from this, neither are they benefiting from resources that are coming out of that. As Maria spoke about loyalties, Kenya's Energy Act, which also speak about benefit sharing. But unfortunately, when we talked about our Carrier 7 project, the company shared that there is no guidelines which are available yet for implementing the Energy Act policy. Therefore, these are some of the limitations that we still see the community struggling through, but training on international policies, they have been actually giving hope on how they can actually seek redress or alternative way of seeking assistance. Therefore, this is what we can say, that through partnership with friends and other partners, we are able to bring the voice of these communities to the table and ensure that they are heard and the issues they are actually going through also be taken care of. And fortunately, I can say our last meeting with the Kenyan and the government and the Kenya National Commission on Human Rights is now giving a lot of hope, because one, the community are able to speak about their issues. Secondly, they also understand the policies which are available locally, domestically, and also internationally. And thirdly, they are able also to hold these companies accountable whenever this process is happening. And therefore, continue building capacity of this local community is of great help. And that's why our organization has been looking at that and believing that that can actually bring a solution to the community. Just to talk about what has happened, giving examples of previous actions, the Russia community, which was actually evicted in 1984, had nothing been done actually to address that one, because by then the community has no understanding, they fear the government, they thought of repression and all that. Therefore, they ran away from the project area. But Narasha community attempt eviction of 2013 is much different from what happened in 1984. This is because the community has already gained some, at least some level of understanding, and therefore they are able to push the government to seek redress to the damages that have been actually done. And that's why the eviction of 2013 did not succeed as it has happened in 1984. And that shows the difference in terms of training of communities on how to deal with projects, impact of the projects. And then we have Olorapil village eviction, which happened in 2017 through the engagement with the European Investment Bank, which were funding and raising the concerns. There was a withdrawal of the funding, and that made the project not continue because the community suffered as a result of that kind of eviction. Therefore, this has been actually truthful cases that has supported the community, show cause why building capacity of local communities is very important. And then what are the communities looking at in each project? We are looking about compensation. Whenever there is damages or there is evictions, there is issues of flooding which are resulting as a result of this activity of these projects, we end up actually engaging with the government and also the projects company implementers to make sure that there is actually adequate compensation. However, there is no enough policies that the communities can use to hold the companies accountable when it comes to flooding, when it comes to climate change issues. There is no still clear locally. And that's why we believe that international protocols or international ways or rules or regulations can actually help in this particular case. We're also thinking of engaging with these projects to ensure that there's community-driven environmental safeguards. Whenever there's national environmental impact assessments, we demand that the companies to conduct their research, their feasibility studies or their environmental assessment in regard taking care of communities' issues and communities' protocols. And then we also pushing for increased accountability and due transparency, because in most cases, information are not disclosed, and therefore the community suffers. And for example, what happened with Orcadia 7, a lot of been happening before we are able to get information, and we came to learn about the project very late when they are already submitted with the National Environmental Impact NEMA for approval. But fortunate enough, because we are able to raise our concern, it has been held a bit to allow the community to give their views and also contribute on how the projects will impact their life. And then, finally, we have been actually thinking about best models for energy exploitation. For example, Kipeta wind power, which the community are in the center state, in the fundamental position when this exploitation of the energy is happening. This is where the community shares are actually discussed. There's disclosure of what the project might impact the community and how it will be addressed. And therefore, this has been one of the projects we can say we are learning from it, and we are trying to push that future project actually to be of the same kind or the same model. Thank you.
Please simply feel free to ask your question. Bronwyn.
I'm Bronwyn Menby. I'm chair of the board of ILP. I would invite any and all of the speakers to reflect on the connection between this last presentation and community engagement in Kenya, but in the Philippines, in any other country as well, and the litigation in British courts or before your Strasbourg court, the European Court of Human Rights, about how we draw those connections and make that legal advocacy most effective.
Would like to answer that? Natasha, possibly.
Yeah, well, I think that's a really interesting question, and one that I'm sure a lot could be said about. Just from the perspective of litigation in Strasbourg, I think two things immediately come to mind. Firstly, as I think I outlined, it's a limit of the European Convention jurisdiction that it is only member states who are party to the convention, and therefore people residing in those territories are able to bring claims. But that doesn't mean that there aren't community groups with interests in the European Convention member states. And as the Swiss women case shows, and also as the Dutch case shows, it's possible for NGOs with interest in order to litigate in the Strasbourg courts. It would depend so much on what the particular interests in play are as to which rights and how you could use them if there is a human rights case to be brought. But that's one avenue where community groups might be able to use an international, in this case, judicial mechanism to support their case. Another way in which NGOs can often support litigation, I think this applies domestically as well, is to provide evidence on impact. And some NGOs may also be able to provide scientific evidence that is helpful to establishing a causal case, but often where there are impacts that are felt by which have an NGO voice, then witness evidence from people affected by the community can then wait to a case that's being brought through a kind of human rights prism. So those are just two initial ideas. But as I said, that's a really interesting question, and I think others may well have more to say about it.
I just briefly respond in a way that sounds obsequious and ingratiating, but it's not meant to be. But it's kind of doing work with International Lawyers Project has certainly been something that brings that together. So I had the privilege to work briefly with a group in Uganda working on deforestation litigation or bringing strategic litigation against the thanks to Maria and others, NGOs building those bridges and ensuring those teams, local communities, people working in different areas of the world, people with the legal knowledge are brought together.
Yes.
Thank you. I'm Laurie. I'm from Mishcon Durea in the Mishcon Purpose team. Thanks for all the interesting contributions. I wanted to pick up on a comment that Jackson made at the end about grievance mechanisms that are typical in infrastructure development projects across the world, usually involving development banks of kind of sort of public development bank type. And I wanted to ask anyone on the panel what your experience was of those types of proceedings, and whether they tend to promote a quick disposition of the issue and bring about an effective remedy, or whether they kind of kick the can down the road and actually starting litigation sooner might have focused minds more effectively. Thanks.
Who wants to take that?
I can briefly respond with some brief experience, but it's limited to one issue that I didn't advise on, but my firm did, where a local community was affected quite significantly by a mining company's activities and some activity within the company that the company said it didn't have responsibility for, but there are some really egregious allegations there. As part of a settlement, a grievance mechanism was set up, which included within it kind of ongoing dispute resolution structure for various issues, as well as funding for various community projects. Now that helped resolve that issue, and as far as I'm aware, it means the company needs to continue to put money and effort into making that work. So I think it doesn't necessarily kick the can down the road because there is an ongoing commitment. I don't know that litigation earlier would have necessarily resulted in a different outcome. I'm not sure that the company in those circumstances, I mean, it did push back obviously for months, if not years. I think it can work within resolutions within as it does in responding to settling OECD complaints as well. So I think they're quite important and do work and are useful, but others may have different experiences.
I suppose much. Oh, I've got to.
Go ahead.
So my experience has been more in the context of UK infrastructure and the sort of what's called the development consent order process, and there it's very much discouraged to litigate early on. Basically, you've only got 6 weeks after the development consent order has been granted for you to actually bring a legal challenge. Up until that point, though, there is, I suppose, what you might call a dispute resolution mechanism, which is a public inquiry or a series of public examinations where people are allowed to bring issues that they have with the proposed development, make submissions on them, often have legal representation, bring in experts. The developer will bring in their own experts, other parties will bring in experts as well. And the idea is that those disputes will all be worked out and then resolved by essentially a panel of examiners who then make a recommendation to the Secretary of State. And then the Secretary of State will ultimately decide what the outcome is. And if you don't like the outcome at that stage, then you can judicially review within that very narrow 6-week window. Would it be better to have that as legal challenges at an earlier stage? I think probably not, just because it would draw out the process for just a lot longer. I mean, the reason why this streamlined process was brought in was because it was taking 5 to 10 years to get anything built, essentially.
Lucy, do you have a question?
No, it's more that I saw Jackson had his hand up.
Oh, okay. Jackson, do you have a comment or a response to that question?
Yeah, in fact, I want to say it is more complicated because looking at the both sides, the legal and the alternative resolution. For us, we have experience of the two, and fearing the long time that the legal process actually takes, we always think of alternative resolution as a mechanism that can actually help in solving problems. But taking, for example, what happened in 2016, 2017, 2018, our Career 4 project, we still struggle up to now, 2024, on what was agreed upon, but when it comes to implementation, has never been happening. And this is why it was saying it's complicated, because issues of enforcement became a challenge. Take, for example, what happened with the Ogiek case in Arusha. It has been decided a long time, but still enforcement is taking too long. And that's delayed justice is actually denied justice. And this is what the community has been actually trying to seek redress. And the earlier the better, because, you know, it continued to impoverish the community. For example, in our Area 4 project, the community which have been relocated and took the case to World Bank and the AIB, you know, they have been actually reduced to just very poor people. They cannot practice the normal livelihood that they have been actually doing, pastoralism and others. Therefore, you can say it is a very serious and a concern when it comes to communities, because if these issues are not addressed immediately, then the suffering will continue, and it affects the community very seriously. And this is whereby we look at, we wish to ask, if possible, we can get mechanisms or policies that can ensure that these projects are held accountable and do not delay the issue of implementation of those resolutions or decisions that are made both legally through a legal process or through alternative mechanisms.
on that,
Yes.
yeah, because
Natasha.
and in relation to, was it Laurie, your question as well, I don't have direct experience of working with grievance procedures, but I think applying more of kind of a transitional justice framework, it seems relatively inherent to the nature of the procedure in question as to what its success is likely to be. And what Jackson was saying there about the ability to enforce any mechanism that is set up, I think is critical. So if there's a procedure that properly allows for people in order to be recompensed for their grievances with proper courses for enforcement and opportunities for redress, including legal redress, if the can does need to be kicked down the road and it doesn't operate as intended, then that potentially seems to me like it serves a quite useful mechanism for addressing potential issues at a community level. But if it's an empty kind of essentially greenwashing procedure which doesn't actually allow anyone to achieve any sort of justice, and ultimately then requires litigation down the line in order to achieve its intent, then that seems like an obvious negative. So that's essentially implicit in your question, but I wonder if that's kind of the
We have time for one more question in the room, and then we'll take one online because we slightly exceeded our time, please.
My name is Jake White. I'm head of legal advocacy at WWF UK. Thanks for this evening's session. I suppose the question in my mind is, when one has regard to the sort of International Labour Organisation's definition of just transition, so not leaving communities behind, I suppose the question in my mind is whether social and economic rights are a slightly underexplored or underutilised area in the just transition space. And I suppose what I have in mind is rights like the right to housing, the right to sanitation, the emerging right to water, right to an adequate standard of living. Obviously, bearing in mind scepticism in jurisdictions like this, and possibly other common law jurisdictions, about social and economic rights. But whether that's an avenue we could explore more fully to address head-on the risk of, as the ILO defines it, communities being left behind as we transition to net zero and age positive.
Alex, would you like to?
Yes,
answer that?
absolutely. And I think the real benefit to trying to think outside of the box and that sort of usual, typical, in an environmental case, environmental judicial review grounds, and trying to go and basically be like a magpie and find other areas of law and like bring them in, for example. One example of that is when we tried to challenge the Napier Barracks asylum accommodation via a planning challenge rather than a human rights challenge, and managed to establish that the PSED had been breached in that case, for example. I think I spoke earlier about PSED, so a public sector equality duty and equality rights as well. That's certainly something that I think we should be exploring a bit more in the environmental space, because it's pretty mature legal duty now, and it kicks in basically in any kind of public function at the moment. So yes, I think we definitely should be looking outside the box a bit more.
Okay, we've got time for one question online, which is asked by Iris Bankin. And that question is, to what extent do non-binding frameworks such as UN guiding principles on business and human rights encourage companies to mitigate climate-related risks that could harm vulnerable communities? What weight does or can such non-binding frameworks carry in the space of climate litigation? Robert, that question to you, perhaps.
Maybe can be forgiven for feeling in a cynical mood and pessimistic mood this evening. And in terms of climate litigation, I would argue probably ultimately not a huge amount of weight, at least as a primary, well, it's not a cause of action because it's non-binding, but a primary platform. If I can kind of bang my reputation drum again, though, I think where you have, and I use this term relatively, responsible companies that care and are invested in those principles, and there are many now for whatever reason, they can be and are very useful to have in order to highlight any shortcomings, breaches, failures, and that can help promote action in other ways. So I think probably a good trigger, should be taken seriously and can be very valuable. But in terms of litigation itself, weight is probably variable, negligible in some points. And if anyone disagrees, again.
Alex, I know you had some thoughts about joining up the litigation and will.
Oh, right, absolutely. Well, I think absolutely you need to join up litigation and political and get your political objectives lined up as well. So you might have a great legal argument, for example, but you need to follow it through. Think, well, what does success look like? And there are situations where you might succeed in court, but ultimately not get a good political outcome. We might lose in court, but actually get quite a good political outcome.
Well, I think that brings us to the end of this panel discussion, and I'd like to thank everyone in the room who came out and everyone online. Big thanks to Jackson, who joined from Texas. And thank you for bearing with our technical issues. I'd love to thank Landmark Chambers, and in particular, Joss Kitchen and the practice team. Ben Connor, practice director, of course, Maria Christina, and the ILP team for their help in organizing and running today's seminar. And hopefully we're going to take this forward with us when we leave here today. For those of you in the room, please join us for drinks and canapes afterwards. And finally, thank you again and goodbye to our online participants who are joining us from different countries.
Thank you.